Χαίρετε. Επιτρέψτε μου να δώσω την ομιλία μου στα αγγλικά, καθότι αυτό μου έχει ζητηθεί. Είναι και η επίσημη γλώσσα λειτουργίας της Ευρωπαϊκής Εισαγγελίας, την οποία εκπροσωπώ σήμερα. It is a great honor and a pleasure for me to be here today to address the esteemed audience of the Cyprus Forum 2024. I am truly grateful to the organizers of this conference, the Oxygen for Democracy, the University of Cyprus, and its strategic partners, the Delphi Economic Forum and Xenox Public Affairs. The invitation has been extended to me in my capacity as European Prosecutor in order to deliver a speech about and on behalf of the EPPO, the European Public Prosecutor's Office. In a nutshell, our mission is to investigate and bring to justice the perpetrators of crimes committed against the financial interests of the European Union, including procurement fraud or subsidies fraud, VAT fraud or customs fraud, bribery, whether passive or active, misappropriation by public officials, and money laundering. The constituent elements of the crimes and the minimum sanctions in case of conviction were prescribed by the Directive of the European Union 1371 of 2017. To fulfill our mission, we adopt a harmonized approach in setting priorities for investigation and conducting action days across what we call the EPPO zone. Our goal is to ensure that crime does not pay. We apply to national courts for freezing the illegal proceeds to enable the national authorities to recover any damage upon conviction of the criminals. This is the way to protect the EU taxpayers' money and, in the long run, to gain the trust of EU citizens. Legally speaking, we derive our powers from the Council Regulation of the European Union 1939 of 2017, which was adopted in Luxembourg on the 12th of October 2017 and entered into force on the 20th of November 2017. It was the result of the enhanced cooperation of initially 16 member states of the European Union, which expressed a common wish to set up a prosecutorial authority at EU level, the first and only of its kind, as foreseen by Article 86 of the Treaty on the Functioning of the European Union. Cyprus participated from the very beginning in the enhanced cooperation to this effect. Progressively, 6 more member states adhered to the enhanced cooperation, and when the European Public Prosecutor's Office commenced its operational activity on the 1st of June 2021, it already encompassed 22 member states. During 2024, Poland and Sweden have officially communicated their wish to take part in the EPPO, and the appointment of their prosecutors is now underway. Hence, currently, only Denmark, Hungary, and Ireland are considered as non-participating member states in the so-called EPPO zone, which extends to 24 member states and covers almost 95% of the EU spending revenue area. However, one should not ignore that the EPPO may investigate not only offences committed in whole or in part within the territory of the participating member states, but also offences committed anywhere by a national of a participating member state or by an EU official, provided that a member state has jurisdiction according to its national criminal law for those offences, even when committed outside its territory. This extension of jurisdiction reflects the fact that the economic crime is not confined within national borders. It expands transnationally. This is particularly so when we speak of organized criminal groups. Consider that out of 2,875 EPPO investigations over the last 3 years, 377 cases relate to transnational organized criminal groups. The ongoing Admiral investigation, as it is named, in the field of VAT fraud is an example worth mentioning. The investigation was initiated following a report by local tax authorities of a member state regarding a missing trader fraud allegedly committed by a single company. Within 6 months of investigation, the EPPO found the links of the professional money laundering criminal group, which was behind this fraud, which operated not only in France, Portugal, and Italy, which are participating member states, but also across North Africa, Israel, the United Arab Emirates, Serbia, and Albania. The analysis of the seized data, which is still ongoing, revealed evidence not only of crimes within the EPPO's material competence, but also links to drug trafficking, illicit cigarette production, investment fraud, illegal gambling, prostitution, and other economic financial crimes. Therefore, the EPPO transferred to national authorities several files which were used by them as key evidence for initiating 28 independent investigations. Wisely enough, in setting the map for the EPPO, the regulation granted it the power to enter into working arrangements with the non-participating member states of the European Union, as well as with third countries and international organizations. In this way, the operational cooperation with those countries was facilitated. There were arrangements for the surrender of suspects of crime, exchange of strategic information, and it was possible for them to second liaison officers to the EPPO central office in Luxembourg. It is noteworthy that the EPPO has already developed a network of international partners, including various anti-corruption authorities, such as the Anti-Corruption Authority Bureau of Ukraine, the Albanian Anti-Corruption Structure, the Anti-Corruption Commission of Seychelles, other international bodies such as the World Bank, national authorities of third countries such as the United States Department of Justice and the Department of Homeland Security, and the Prosecutor General's offices of other countries which are now receiving the candidate of EU for accession member states. The list is non-exhaustive. The figures about the EPPO's operational results are striking. The amount of value of assets frozen increased from 147 million at the end of 2021 to 1,500 million at the end of 2023. The indictments submitted in court increased from only 5 at the end of 2021 to 139 in 2023. There was one conviction in 2021, 48 in 2023. We apply also the simplified procedure where a plea bargaining system exists in the participating member states, and we had 56 such simplified procedures only in 2023. Cyprus has now 14 open case files where we have ongoing investigations. And our office in Cyprus, headed by the European Delegated Prosecutor, has assisted other participating member states in approximately 80 cases in the last 3 years. What renders the EPPO attractive to the outside world is not the operational progress it scored alone. It is primarily the independence which is embedded in its structures and in its decision-making processes, as well as its avowed conformity with the legality principle. It is also the democratic legitimacy it derives from the way its members are appointed and by being accountable for its results and for the respect of rule of law to the European Parliament and to the national parliaments. As the European Chief Prosecutor, Ms. Laura Codruta-Kovesi, put in her own words in a speech she delivered in Brussels on the 15th of March 2024, it is important how citizens perceive us, whether we are independent or servile, whether we are courageous or scared. If we really want to save the rule of law, the key is to win the hearts and the minds of the people. The EPPO is bound by the Union value of the rule of law, as it consists in the principles of legality and of legal certainty, the prohibition of arbitrariness, the right to effective judicial protection, including the right of access to justice by independent and impartial courts, the separation of powers, executive, legislative, and judicial, And last but not least, the principles of non-discrimination and equality before the law. It is expressively stipulated in the preamble of the EPPO regulation that it will be guided by the legality principle when it takes decisions about the exercise of its competence, the initiation of investigations or the termination of them, the referral of a case or the dismissal of a case, and whether to apply simplified prosecution. In Cyprus, due to the common law tradition, our prosecutorial system has been more accustomed with the application of the opportunity principle, where the Attorney General has a wider margin of discretion in deciding if it is in the public interest to initiate investigation or to terminate investigation and withdraw charges pending the trial phase. The Attorney General's powers in that regard are not subject to judicial review. We at the EPPO have a more stringent system as regards the reasons why a case may be dismissed at the investigation stage, and these are prescribed specifically and exhaustively in Article 39 of the EPPO regulation. As regards our independence, Article 6, Paragraph 1 of the EPPO regulation explicitly demands that the members, those being the European Chief Prosecutor, the two Deputy European Chief Prosecutors, the European prosecutors coming from one from each member state, shall act in the interest of the Union as a whole and neither seek nor take instructions from any person external to the EPPO. This was essentially the content of the oath I have taken on the 30th of November 2023 during the solemn ceremony before the President of the Court of Justice of the European Union in Luxembourg in my capacity as European Prosecutor. Article 6, Paragraph 1 of our regulation creates a corollary obligation for the member states of the European Union and the institutions, bodies, offices and agencies of the Union not to seek to influence us in the exercise of our tasks. As regards the procedure for the appointment of the members of the College of the EPPO, the eligibility requirements for appointment place a guarantee for our integrity, impartiality, and independence, since no one can be nominated as a candidate European prosecutor unless he or she was an active judge or prosecutor enjoying of independence beyond any doubt at the time of nomination. There is also a provision in the EPPO regulation that our legitimacy at the time of appointment is drawn from the institutions of the Union which are involved in the appointment procedure. Our interviews were carried out by a selection panel which comprised 12 persons chosen from among former members of the Court of Justice and of the Court of Auditors, former national members of Eurojust or of national Supreme Courts, high-level prosecutors and lawyers of recognized competence. One of the persons in the select panel had to be proposed by the European Parliament. As regards the dismissal of any member of the EPPO, a national government alone does not have the power to take the initiative to remove from office either the ECP or an EP. Article 14, Paragraph 5 and Article 16, Paragraph 5 provide correspondingly that it is the Court of Justice of the European Union which may, upon the application of the European Parliament, the Council or the Commission, to dismiss the European Chief Prosecutor or the European Prosecutor, and this only if it finds that that person is no longer able to perform his or her duties or that it is guilty of serious misconduct. We remain accountable for our execution of tasks to the European Parliament, and this is specifically provided in Article 6, Paragraph 2. We follow the principle of equality before the law by ensuring that every person will be investigated regardless of status or hierarchy within national structures. And we apply for the lifting of privileges and immunities if necessary according to Article 29 of our regulation. We provide all the procedural safeguards for suspects or accused according to Article 41 of regulation, as they would be provided by national prosecutorial authorities because they are prescribed by directives of the European Union as regards their right to choose a lawyer, to remain silent, and to have the presumption of innocence in their favor, and also to be informed about the case materials that we have in our files. Access to justice is also guaranteed by Article 42 of our regulation, because there it is prescribed which acts of the EPPO may be challenged before national courts and which before the Court of Justice of the European Union. In view of the above provisions, the EPPO has a complete toolset for respecting the Union value of the rule of law, and it is determined to do so in each and every respect. If I were to convey a message today, it would be that it is worth allocating further resources to this prosecutorial authority, in particular to dedicate more police investigators and more funds for digital analysis of a huge data set resulting from its investigations. Thank you for your attention.